Self-defense is a justification defense. I think it's one of the most underestimated or a defense that most people don't particularly understand. So I'm going to take you through several examples of self-defense, when it is, when it isn't. There are rules relative to it. And like I said, there's a lot of when you can use or stand your ground, when you can use defense, and when you can use deadly force in defending yourself. So that's what we're going to cover. It is a justification defense. You've committed the crime. You did the act. You did the criminal act. Killed somebody. But the argument is you were justified in doing so. Various crimes that this does apply to. Things like assault, homicide, battery in some states. New York doesn't recognize battery. It's considered an assault. And this justification defense, the defense of self-defense, is outlined by statute. So you will find it in the criminal code somewhere, and it's raised as an affirmative defense. It can also be a perfect defense or an imperfect defense. Kind of a recap or a reminder. It can operate one way or the other. So you get a full acquittal. The defendant gets a full acquittal. That's a perfect defense. They get a reduction in the charge from the severity, basically a severity of the offense. It's an imperfect defense. They're still found guilty, but of something less than what they were initially charged with. And at times, a defendant may use deadly force. And what constitutes deadly force differs from state to state. Well, not what deadly force is, but how it can be implied. It differs from state to state. So what is deadly force? Any force that can potentially kill. You don't actually have to kill someone. It just has to have the potential. So if a defendant has used a knife, a gun, a vehicle, a metal bar, a club, a bat, anything using to protect, because we're arguing self-defense, to protect themselves, the question is, were they in a situation where deadly force was allowed to be used? And where that exists will differ from state to state. So let's talk about what you need as a defendant. Remember, it's an affirmative defense, and it's up to the defendant to prove this affirmative defense in most states, not in New York. In New York, it's on the burden of proof is on the prosecutor to prove that justification wasn't had in a particular case, and they have to prove it beyond a reasonable doubt. In other states where the defendant has to prove it, their burden of proof is by a preponderance of the evidence. So remember that distinction. So what do you need? These four elements have to exist. The defendant, this is where a defendant is proving self-defense. Defendant was confronted with an unprovoked attack. And we'll go through these in more detail, but for now, let's talk about them generally. So defendant's confronted with an unprovoked attack, meaning the defendant didn't start it. And that threat of injury or death that is forthcoming, it has to be immediate, imminent. It has to be, it's right there. Can't be some threat over the phone from an hour before. The force used has to be objectively reasonable. We've had this term before. We're going to see it again. Objectively reasonable. That means our test is, what would a reasonable person in the same situation find those circumstances to be? So if we're talking about, a fist fight brawl, someone goes to hit you, you can hit them back with a fist. You can't pull out your gun and shoot them. This is what we're talking about, objectively reasonable force used. Defendant has a objectively reasonable fear of being injured. Again, what would a reasonable person in the same circumstances feel? Would they feel a fear of this injury or death? So these are the four things that need to be present. Let's poke them through them one by one. Provocation. Like I said, you can't be The defendant cannot be the intimidator. There are some exceptions, however. That is when the attacked individual responds with excessive force, or the defendant withdraws from the attack, but the attack persists. Okay? So let's talk about what each of these constitutes with using an example. So Mike and Fred are arguing in the kitchen over a football game and who won a certain bet. Mike's frustrated. He shoves Fred into the counter, and there happens to be a knife holder right there. It tips over, it spills out some knives, and Fred grabs one and comes at Mike. They wrestle. Mike gets the knife and stabs Fred in the chest, killing him. Mike is arrested for murder. So our question is, does he have a defense of self-defense? Well, who was the aggressor? Mike was. Mike started. He shoved Fred. But what happens next? Fred responds with an excessive use of force, and that is a knife, and comes at Mike. So Mike has to wrestle and get the knife away, and Fred ends up stabbed in the chest. Even though Mike was the aggressor here, the response was excessive force. So in this case, Mike will be able to use the self-defense claim, even though he provoked it. So Mike and Fred are arguing in the kitchen over a football game and who won a certain bet. Mike is frustrated, shoves Fred, who falls on the floor. Mad, Fred gets up and runs into Mike, who is just standing there eating a potato chip, tackling him to the ground. Fred is tackled by other guests, and Mike suffers a broken arm. What do we have here? Is this a good use of self-defense? What would a reasonable person think? Mike just shoves Fred to the floor. It's over. Mike's now eating potato chips. But Fred is mad, and he gets up and he runs into Mike and tackles Mike and breaks his arm. Fred could not use self-defense here. The immediate threat is over once he is pushed and shoved to the ground. What is Fred doing here? He's retaliating. This isn't self-defense, even in a state where there's a requirement that you have to withdraw, which we'll talk about in a second. I just want to distinguish that in this scenario, it might be annoying that you got pushed to the ground, but unless Mike's still coming at you, it's over. And what happens next is retaliation. So we talked briefly about withdrawing. Well, let's stay with withdrawing before we do this next example. So what constitutes withdrawing? In that example, Mike goes on to eat potato chips, and under the circumstances, a reasonable person would believe that this fight is over. And depending on what jurisdiction you are in relative to withdrawing from an attack, you have to have the actual withdrawing from the attack and communicating that withdrawal. And you don't necessarily have to say, yeah, I'm done here. Sorry I shoved you. Just based on the circumstances. And not all states recognize this withdrawal, but most of them do. And in this instance, in that last example, it's going to be considered retaliation. So you have to look and see what happens with the aggressor. Is he still aggressing, still moving forward, or did he or she step away and withdraw? Okay. Next example. Instead of grabbing the knife after Mike shoves him, Fred shoves Mike back. So we got Mike shoving Fred, Fred shoves Mike back, and Mike runs into the bedroom, and Fred gives chase. Mike apologizes, but Fred throws a punch, and Mike ducks. That's supposed to be ducks, not ducks. Different kind of ducks. Ducks and roundhouse kicks Fred, causing him to fall, hitting his head, knocked unconscious, and now Mike is arrested. Does Mike have a defense? What do we got going on here? So we got an okay shove, and maybe we're over and nobody's hurt, right? We have a shove, but Mike's like, I'm out of here. I'm running to the bedroom. Is that withdrawal? I would say that's a pretty good sign that Mike's done fighting. But Fred chases him down. So Mike is no longer considered the aggressor. It's just switched hands. And Mike's like, well, I'm sorry. Still withdrawing. Fred's not withdrawing. And he punches him. What happens? Mike has to defend himself. Roundhouse kicks Fred. So Mike's arrested. Does he have a defense? Yes, he does. So that's how provocation works, or at least we've met the element of provocation. But I set this up so we would see the entire thing unfold as self-defense. Nope, sorry for the momentary delay. All right, imminent. And I thought I paused, but I didn't. Let's talk about the next element. No force unless there is an immediate attack, okay? And we kind of had that with our Fred and Mike examples. Can't be a future attack, can't be one based on the past. You can't use any force unless faced with an immediate attack. Someone calls you on the phone and says they're coming over to kick your butt, and an hour later they pull into your driveway. You meet them out there, and before they're out of the car, you punch them in the face. Yeah, that's not it. Okay, you can't say self-defense based on that. The appropriate response would be to call law enforcement. So, no immediate. It's not immediate when it's something in the future. Let's go back to Mike and Fred. Mike and Fred are fighting over the fantasy football stats. Mike is joking with Fred, telling him how horrible his picks are. Fred gets mad and punches Mike in the side of the head, leaving a bruise and a red mark. Mike shuts up and doesn't do anything. After stewing on it, the next morning, Mike shows up at Fred's house. Fred opens the front door, and Mike punches him in the face. And Mike is arrested for assault. Does Mike have a defense? And I hope you're shaking your head. No. This would probably be called retaliation. And it's not imminent, right? Didn't happen immediately. Even if Mike waited a minute after that took place, that may constitute retaliation than self-defense. Now, there is an exception to, not this particular example, but there's an exception to the imminent component of this. And there is this concept that is called the battered wife syndrome. It's in domestic violence cases where a husband, I want to say a spouse, I don't think this works the other way. I don't think you have a battered husband defense. I've never heard that used before. That may very well exist out there. But the battered wife defense is something that is significant, and it's actually even written in statutes, at least it is in the state of New York, that can be used. Domestic violence cases where a husband regularly uses violence against his wife. Basically, there is a threat of imminent harm every day. Wife can legally use the force against abusive husband, even when the harm wasn't necessarily immediate. So let's say it's, 10 years of constant physical and verbal abuse, and one day she just snaps, and while her husband's sleeping, she takes out the gun that they keep in the house and she shoots him. Clearly there's no imminent risk of injury or death at that moment because he's sleeping, but courts have allowed that defense to stand because of the fact that that's what she endured every day, and that threat existed every day when they woke up. That does not mean, yay, let's go out and shoot our spouses. That's not how this one works. This would not be a, yep, this is self-defense and you get to go home. This would be an imperfect defense if that occurred in that situation, because as I described it, she's intending to shoot her husband. This would be a murder one. It results in something less. Very much like the spouse who walks in their bedroom and see their spouse with somebody else in bed. It's there's something that affects the criminal intent component, but we don't treat it as self-defense. It's a different kind of defense here. It's called the better wife defense. All right, our next component, proportional. What degree of force was used? You got to ask yourself these two questions. What degree of force was used? What is the threatened harm? You have to determine this, like I said, by the reasonable person in that situation. You got to use the objective standard test, not the subjective standard test. And what would be the subjective standard test? That's based on what the defendant is thinking, and that's not what happens. How the defendant sees it to be. It's how a reasonable person would see it to be. And it cannot be disproportionate to the threatened harm or the force necessary to avoid the harm. The point is to avoid the harm, not to get into an altercation and get yourself hurt or killed. It's to avoid the harm, right? And you can't use deadly force unless legally justified. And when can it be used? Deadly force. This is using something that can ultimately lead to death. Deadly force. So when can it be used? In New York, it's actually very spelled out when you can use deadly force. In 3 situations: to avoid your own death, if somebody else is using a gun, you can use a gun. Robbery or burglary of your home and your home. You're in the house and somebody is breaking in to commit burglary or robbery. And that person is in your home, not hanging outside the window or the front door. They're in your home. Or in the course of a sexual assault, you can use deadly force. And actually, let me be more specific. Not because when we get to sexual assault cases and sexual offenses, you're going to see there's a wide range of them. During the course of rape, that's the only time you can use deadly force in the state of New York. So only on 3 occasions. The Model Penal Code, deadly force is not reasonable unless the actor believes that such force is necessary to protect himself against death, serious bodily harm, kidnapping, or sexual intercourse compelled by force or threat. So that is rape. Notice how the Model Penal Code doesn't allow it for robbery or burglary of a dwelling. So let's jump to some examples. Nick is an intruder, pins Wanda to the floor of her garage and begins to forcibly remove her clothes. She feels around on the floor with her hand, finds a screwdriver and drives it into his neck, not her own, his neck. Nick dies. Wanda's charged with murder. Would this be self-defense? Yes. It's rape, serious felony. He can certainly kill her. He could certainly do serious injury. Was deadly force justified? Put yourself in the reasonable person standard. Would somebody in the reasonable person? Yes. What if he finishes the act and has raped Wanda, and he gets up and he starts walking towards the garage door that leads to outside? While he is fumbling with the lock, she grabs a shovel and hits him over the head, killing him. Is that self-defense? Do we still have the immediate harm? Is it self-defense or is this retaliation? This is going to be retaliation. It's what has happened, and now it's over. Deadly force justified, and he dies, because in my example she whacks him over the head with a shovel, and we'll say he dies. Deadly force justified? Probably not. Will she catch a sympathetic ear? More than likely. I would be shocked that a prosecutor would charge Wanda with murder. She would be charged with something probably less than that, but she might catch a sympathetic jury ear nonetheless based on the circumstances. But my point of this is how you determine what is self-defense and when deadly force is justified. So let's talk about a couple more. Oh, that was just my example. Wanda grabs a shovel, hits him over the head, killing him. Wanda's charged with murder. We've already discussed that. Sorry, I didn't click. Let's talk about these two. Murray is 5'3", weighs 120 pounds, and Rocky is 6'5" and weighs 240 pounds. Rocky instigates an argument with Murray at a local bar and carries out a threat to beat Murray to a pulp. Murray takes out a gun and shoots Rocky as he reaches for Murray. Murray's charged with murder. Do we have self-defense here? And I certainly don't tell you if Murray is male or female, or if Rocky is male or female. Would that play a role? Think about it for a moment. Here comes Rocky, who's 6'5", 240 pounds. He's coming at Murray. He's going to carry out the threat to beat him to a pulp, and Murray takes out a gun and shoots him. Would a reasonable person, under the circumstances, believe that using the gun was justified? Using deadly force? This is a tough one. I think if I told you Murray was a female, this might stand up. Even if it was a male, this might still be self-defense. How is else, unless Murray is a black belt in karate of some sort, it's going to be hard to defend yourself against Rocky, the big dude. What if the roles are reversed? What if it's Murray who's the instigator and is going to tell Rocky he's going to pound him to a pulp? And he's going to go and carry out the threat, but then Rocky pulls out a gun and shoots Murray. What would a reasonable person in that situation, under those circumstances, feel was the use of deadly force in those circumstances okay? Probably not. So you got to see how that would be as the reasonable, prudent person in those circumstances. And you got to look at the facts of each situation. Duty to retreat versus stand your ground. And we have heard all about this stand your ground. It's not necessarily a new law, even though it seems like social media and on the internet are treating it as, this new form of a law regarding self-defense. It's certainly big in the South. Florida, namely, a lot of cases come out of. I'm sure you're familiar with the Trayvon Martin case. Robert Zimmerman was found not guilty for shooting the young man down in Florida who was unarmed. He was claiming they got into an altercation and he was standing his ground, and the other individual, Mr. Martin, didn't have a gun or a weapon. So let's talk about duty to retreat versus stand your ground. In early common law, the defendant had a duty to retreat. What do we mean by that? If you're in a confrontational situation, you needed to get out of there. If you can get out of there without being harmed, you needed to get out of there. You had a duty to retreat. The stand your ground option came later. and was incorporated in the statutes, but you only get to stand your ground if you're not the initial aggressor. That still applies. The Model Penal Code says use of deadly force is not justified if actor knows that he can avoid the necessity of using such force with complete safety by retreating. So the Model Penal Code recognizes a duty to retreat, and there's some states who have adopted that. New York State is a duty to retreat state. You must use all means necessary to get out of there if none can use without having to use deadly force. Now, states like Florida, they have this stand your ground rule that basically got rid of the necessity of avoiding the use of force. Okay, it still has a retreat option. Didn't make it mandatory that you have to get out of there without using. We're talking about deadly force. We're not talking about punching each other or, hand-to-hand issues. We're talking about using deadly force. If you can get out of there, you have a duty to retreat under the law, and that's an issue of fact. That's an issue that the prosecutor would have to show to a jury, and a jury would have to decide. So I just want to be clear that it's not, hey, I shoved you to the ground, and then I step back after I shove you to the ground, and you pull out a gun and shoot me and say, stand your ground law. That's not how it works. Okay, so let's talk about it here. A person is justified in using deadly force if he or she reasonably believes that using such force is necessary to prevent imminent death or great bodily harm to himself, another, or prevent a forcible felony. Okay, a person who uses deadly force does not have a duty to retreat and has a right to stand his or her ground if the person is not the aggressor and has a right to be where she is. So if this occurs on property where you're not supposed to be, even if you're not the aggressor, if you're not supposed to be there and you use deadly force, well, then you're not going to be able to get out of this self-defense rule. So stand your ground, right? It just got rid of the duty to retreat, but you still have to be in imminent harm's way. It's not so when I gave you that example of we're having an altercation and I shove you and you fall to the ground, but after I shove you, I don't come at you, I back away, and then you pull out a gun and shoot me. Were you in imminent harm of death or great bodily harm at that point? So the question becomes, is that retaliation at that point? I mean, you only have a few seconds to think about these things when you're in the moment, right, when it's happening. So let's look at, there is one other point I want to make before I flip to my examples here on stand your ground. The belief here, I want to point it out in the language here. A person who uses deadly force does not have a duty to retreat and has a right to stand his or her ground if the person is not the aggressor and has a right to be where she is. And up top it says a person is justified in using deadly force if she reasonably believes that using such force is necessary. So this language that I bold up here on top is very important, because when you see he or she reasonably believes, we're talking about that, well, we'll just call them the defendant because that's who they are at this point. That's their subjective belief, right? This statute gives the subjective belief, what that defendant thought in that moment, he or she reasonably believes. It's subjective to the actor. And that is a point that they will have to prove when raising this defense. The defendant would have to prove. But on the flip side of that, the trier of fact, who's the jury or the judge, has to determine under an objective standard, a reasonable person in this situation, that it was objectively reasonable to believe that the dead person, because now we have the dead person, was about to do death or bodily harm. That's the second portion of the top part. So the first part of it is subjective. What did the defendant believe or the actor believe? In the second part, was the dead person about to do death or bodily harm? And that's from an objective point of view. Let's talk about some examples. Sandy and Sue have an argument in the park. And let's say we're located in the state of New York. Sue pulls out a knife. Sandy also has a knife. What can Sandy do? If we're in New York, I don't give you any more facts. Sandy has a duty to retreat. So she has to see if she can get out of there, not pull her knife out and go at Sue. Sue just pulls a knife out. Does Sandy pull her knife out and, hey, let's have a knife fight? Sandy needs to get out of there if she can do so safely in the state of New York. If she can't, because Sue is already coming at her, then she's free to use the knife. Stand your ground state. I like to call it the Wild Wild West. Sue pulls out a knife. Sandy also has a knife. And if Sandy is legally in a place, now we're in a park, so they both have the right to be there. Sandy doesn't have to retreat. We can show down. Maybe Sue will back away when she sees Sandy also has a knife, and it'll de-escalate. But that's how the stand your ground state works. What if Sandy pulled, flip to my next. What if Sandy pulled the knife first? Sandy pulls the knife first, lunged at Sue, but misses. Sue pulls her knife out and stabs Sandy in the arm as she staggers past her because she misses. Sandy swings her arm back and stabs Sue in the eye, hitting her in the brain, and she dies. And Sandy is charged with murder. Do we have a self-defense claim? Can Sandy claim self-defense? How about in New York? Probably so. She has a duty to retreat. Can she at this moment? I hope you're shaking your head. You got it wrong, Professor. Sandy is the aggressor. Right? Sandy is the aggressor. She pulls the knife first and she's lunging at Sue. Sue pulls her knife out in that instance and stabs Sandy as she's in the arm as she's staggering by. Sandy swings her arm back and stabs Sue in the eye, hitting her in the brain. Sandy is the aggressor here. Sandy is not going to be able to claim self-defense because she started all of this. How about, do I have an example? Oh. What if you can't retreat? Can you use deadly force? Depends. We can only claim self-defense if a reasonable person in the situation would believe that self-defense is necessary to avoid serious injury or death. So what the defendant honestly but unreasonably believes is self-defense could be necessary under the circumstances. But if you cannot retreat and the other person is using force, you can use deadly force if you're in New York State in any of those situations to prevent death or serious injury, burglary or robbery, or rape. And obviously, if you're in a stand your ground, you don't have to retreat at all. You can stand your ground, but you have to be at risk of imminent risk of death or harm. I can't hit that home. That's the issue that ties people up with the stand your ground issue. All right, I want to do one more. What else do I got? One more thing here. I want to talk about success. What happens if a defendant successfully proves the defense of self-defense? Let's talk about it for a minute. As we discussed early on, real quick recap, who has the burden of proving self-defense or justification in all of the elements? The defendant, most of the time, unless it's specifically stated by a state that it's up to the prosecutor to show that there was no justification, and like that's in New York, okay? Certainly the defendant is going to put on their evidence to show that it was self-defense, but the prosecutor has to put on evidence to show otherwise first. And if it's the prosecutor, the standard of proof is beyond a reasonable doubt. And if it is the defense, the prosecutor is, if it's the defendant, then the burden of proof is by a preponderance of the evidence. And I want to point out imperfect self-defense a little bit more, because it's a common law doctrine, and it's recognized in some jurisdictions in a statute as a defense, as an affirmative defense, it'll say, and an imperfect defense. And we know that a perfect defense, self-defense argument proves all the elements of self-defense, and what it does is it results in the defendant's acquittal. And that would be an example that we used early on with, I think, Mike and Fred. I'll let you buzz back through, so save a little time here. If a defendant, though, proves an imperfect self-defense, as I said, they're convicted of a lesser crime. So if charged with murder, you prove an imperfect defense, it could be something like involuntary manslaughter. Basically, this doctrine of imperfect self-defense, and I just click it over here, this is what it turns on right here. The doctrine of imperfect self-defense is defined as an intentional killing committed with an unreasonable but honest belief that the circumstances justified deadly force. So if a person had a good faith belief that deadly force was necessary to repel an attack, but the person's belief is unreasonable, because you know that what would a reasonable person in the situation do? That person would be able to raise imperfect self-defense as a defense. And it is an actual theory that is defined by statute. It is in the state of New York. It recognizes it as a defense. Does it sound familiar to anything that I've just talked about? The battered wife syndrome, right? You reasonably believe, that person honestly but unreasonably believes that self-defense is necessary. The wife who kills her husband in his sleep because she's been abused for decades, and she believes that risk of harm is coming that day too, but not at that particular moment, that immediate risk. So what else do we got? A couple more examples. All right, Justin weighs over 200 pounds and is 6 feet tall, accidentally bumps into Wanda, who's a slender 10-year-old. Wanda spins around, shaking her fist at him, and he shoves her, and she hits a telephone pole and is killed. Can Justin claim self-defense? What's the question you got to ask yourself? Would a reasonable person believe that the victim, the deceased, was going to cause serious injury or death to Justin? Highly unlikely. He would not be able to claim self-defense. A slender female 10-year-old severely abused Justin when he was younger. Since the abusive incident, Justin has an unreasonable fear of female children and honestly believes that they can and will hurt him if provoked. Now, what if this is now the situation? What's their standard? Does it sound a little like imperfect self-defense? If, in fact, Justin behaved like in the last slide, I'm bouncing off the last slide. There's a case, it's one of the trial cases that you can pick from, the Mendez brothers in California. They claimed battered child defense, that these two brothers were on trial for murdering their parents, and their defense was that they were abused as children. They did a battered child defense. I won't tell you what happened in case you do the trial. Someone does the trial. It's also in this book chapter too. You can read a little bit about it. But in this case, he might have a defense. It won't be an outright full-out acquittal self-defense, but he might be able to get a lesser charge, or a lesser conviction of a lesser charge. Derek, having decided to kill Ron, his enemy for many years, comes up on Ron bending over a package and shoots him 3 times in the head at point-blank range. It turns out that Ron was about to detonate a bomb that would have killed roughly 500 people. Derek claims his killing was justified. Is he correct? He didn't know at that time that Ron was about to detonate a bomb. Is there any sort of argument here? Could it be an imperfect self-defense? Social benefit? Maybe a lesser sentence? Doesn't matter? Like, these are the things that come up under the idea of justification. I don't know. I'm going to leave this right on out here for you to consider. It would be something, if I was representing Derek, I would try. Certainly, we would try. Derek just saved 500 people from being blown up, despite the fact he had intent to kill Ron and did shoot him. So stuff to think about. How about, do I have another one? Oh, just one more. Scott's wife, Diane, constantly physically abuses him. One night while she is sleeping, Scott places a pillow over her face and smothers her. Self-defense. Can he defend against a charge of criminal homicide? Does this kind of defense make sense? We have the battered wife syndrome. Why not the battered husband syndrome? Right? Wouldn't it make sense to have that here? That just might work here too, as well.